everybody. This is Kristin at Flagship Title, and I'm back with Scott Fitzpatrick from Owens Law Group, my favorite board-certified real estate attorney. Hey, Scott.
Hello, how are you today?
I'm great. So today we wanted to talk about how we can hold title. So we brought you back on, obviously, because you're the expert. And so just to start out with, what does holding title mean, and how does that play into for a buyer as far as what is the goal when we're talking about holding title?
Sure. So depending on what a buyer wants to do with the property, and depending on who the buyer wants the property to go to if something happens to the buyer, will depend on how the buyer may want to hold title, because there's different ways you can hold title, and each way has a different effect and different results.
So, okay, so let's talk about single people holding title together. What are the different options for them as far as buying property together?
So if two single people own a piece of property together, they have a couple of different options. One, they could own the property as tenants in common, which is the default, by the way. If it just says person A, a single person, and person B, a single person, period,
Mm-hmm.
then the default is a tenancy in common. Lots of times the deed will go on to say as a tenancy in common, just so it clears up any ambiguity. But just the default in Florida is a tenancy in common. And what that means is, Kristin, if you and I own a piece of property together as tenants in common, and I die, then my 50% of the property is still owned by my estate, even though I'm dead. And then of course you would be a 50% owner. So if you and I own a piece of property 50-50, tenants in common, I die, then you now own the property with my estate. You don't get the property in its entirety, which is the result of another type of ownership, which is what we call a joint ownership of property, a joint tenancy.
Mm-hmm. So, and if I passed away in that scenario, then my 50% would be held by my estate, and then you would own 50% of that.
Correct. And then the court would ultimately determine where the 50% that's owned by your estate goes. Okay. Yeah, it may go to your creditors, it may go to your heirs, but that would all be sorted out in a probate proceeding. But the important thing to remember is, if you own it as tenants in common, unless you buy out the person that you own the property with, you're never going to own the property by yourself.
That makes sense. So what if, and I get this question a lot, because a lot of couples that are engaged are purchasing property, during their engagement versus after they're already married. So in the case that we have an engaged couple and they take property together, what are those options? And then if they were to take title after their marriage, how does it affect it and be different?
So two single people, they can hold title as tenants in common, or they can hold title as joint tenants with full rights of survivorship, which is the second way that you can hold title in Florida. Mm-hmm. And basically, if you and I own a piece of property as joint tenants with full rights of survivorship, the way that differs from a tenancy in common is that with a joint tenancy, then if I die, if you and I own a piece of property 50-50 as joint tenants, and I die, upon the second of my death, the law in Florida says that you own the property 100%. And all you really have to do to perfect your title, or to give notice to the world of your title, is to record an original copy of my death certificate with the clerk of the court in the county where the property is located. Typically costs $10 to do that. And then the records of the county will be changed to reflect, to show that you own the property 100%.
And that would be, we would have to have it say joint tenants with rights of survivorship. It can't just say joint tenants.
Yeah, the proper way to do it is to have the deed say that you and I own the property as joint tenants with full rights of survivorship, and not as a tenancy in common. Now, we see a lot of abbreviations of that and shortcuts, but that is the full proper way to title it on a deed. Sometimes we may see a deed that just names two people and says they own it as joint tenants with rights of survivorship or some form of it. But a joint tenancy is what you want if you want the survivor to receive the whole property at some point.
Now, if this couple, let's say the same couple, was married and they purchased the property and it was going to be a homestead property, how does that differ from if they were unmarried?
Sure. So in Florida, we have a special way that married couples can own property together, and we call that a tenancy by the entireties. And only married couples are eligible to own a piece of property as a tenancy by the entirety. And a tenancy by the entirety is very similar in some ways to a joint tenancy, meaning that if a husband and wife own a piece of property together as husband and wife, or sometimes the deed may say as tenants by the entireties, either way works. But if one of the spouses die, then upon that spouse, the second of that spouse's death, the surviving spouse owns the property in the entirety. And all that surviving spouse needs to do is to record the death certificate, the original death certificate of the decedent, in order to show, so that the county records get changed to basically notify the county that one spouse has passed away and that the survivor now owns the property by themselves.
And just as a side note, because I know that some people are going to be from different states watching this, when it comes to Florida, you're either single or you're married. There's no in between, there's no separated, there's no nothing. You're either single or you're married.
A lot of states have what they call legal separation. Mm-hmm. So, you have three different possibilities. You're either single, you're married but legally separated, or you're married, right? And depending on which one you're in, there are different rights and different responsibilities that go along with that status. Here in Florida, we really only have two statuses. You're either single in Florida or you're married. There is no legal separation in Florida.
Right. So one of the things that I hear a lot about is when people are in the process of divorce, that they want to, buy a new property because obviously they don't want to live in the same house as their ex-spouse now. But, they're taking title to a new homestead property and technically they're still married. How does that play out when they go to sell that property and now they're divorced? Does that spouse still have to sign the deed because that technically was their homestead property?
Yeah, very interesting. And I think I know what you're getting at, and tell me if I'm going down the wrong path here. But I think what you're saying is if a husband and wife owns a piece of property together as husband and wife, which is a tenancy by the entireties,
yes,
and then they get divorced at some point,
yes,
what effect does the divorce have on the title to the property? And the law basically states that upon the dissolution of that marriage, meaning the judge signing the order dissolving the marriage, that tenancy by the entireties automatically becomes a tenancy in common. So sometimes the divorce decree will state that one spouse, the husband or the wife, receives the title to the property. So lots of times in conjunction with a divorce, one spouse has to deed property over to the other spouse. So that we see that very frequently. But if you're married and own property together and then you're no longer married, that title to that property becomes a tenancy in common, without something further like an order from the court saying that one spouse or the other owns the property.
Because I think I've had this maybe one time ever, is that a couple was married, then they got divorced, then they got remarried to each other. So when that happens, they have to they should do a deed to reinstate that tenancy by the entireties or through joint tenants with rights to survivorship, because it doesn't revert back once you get remarried, correct?
Yeah, my recommendation would be in that instance where you have a couple that is married, owns a piece of property as husband and wife, and then there's a divorce, and then later a remarriage, I don't think there's any harm in just upon the remarriage, just executing a new deed, just so that it's clear in the record that they are married and that the couple intends to own the property as husband and wife, and they want those special protections that go along with the tenancy by the entirees.
Yeah, because obviously you want, your spouse to receive the property that they're living in after your death. So just
Correct.
to ensure that happens, that would be a safeguard.
Right. Now another interesting thing, Kristin, that we see a lot is with homestead property. Mm-hmm. We see, what if only one spouse is entitled to a piece of property and it's homestead property, and then that spouse passes away, but the surviving spouse isn't on title? What does that mean to the surviving spouse? And because we're here in Florida, and the Florida Constitution has many different homestead provisions that gives certain rights in property to spouses, to homestead property and spouses, even if they're not on title, that the surviving spouse, in that example that I just gave, even though they're not on title to the homestead property, upon the death of their spouse, would likely either receive a life estate in the property, or may just receive the property outright. The homestead laws in Florida are very complicated.
Right.
And so,
especially when there's minors involved.
And when there's minors involved. So certainly in those types of scenarios, anyone involved needs to seek the guidance of a real estate attorney with those specific facts, because depending on what the facts are may totally change the outcome. But I just want to make the viewers aware that there are these homestead rights, and that even if you're not on title and you're a spouse to homestead property, you still have likely some rights in that property, and you need to know what those rights are so that you can make the decisions that are best for you and best for your family.
Because especially when, a lot of times a couple, one person in that couple, whether that be the husband or the wife, owns property prior to the marriage, and then, the other spouse moves in, that is very common. And, the scenario where something could happen unexpectedly, then you need to have protection, and knowing what your protections are is very important in that scenario.
Sure, maybe the couple had intentions on changing the deed, but life happens and they just never got around to it. And then before you know it, something happens to one of the spouses and the other spouse isn't on title. So, the questions of what does that mean to the surviving spouse? Who gets the property? Is the property subject to the claims of creditors of the deceased spouse? All those are good questions that are somewhat complicated and, need to be thoroughly looked at to determine what the rights of all the parties are.
Absolutely. So you did mention a life estate, and I think one of the other important things that we should talk about is this is frequently used for elderly people, but a life estate in this scenario.
Sure.
If there's an elderly person and they own property, what does a life estate do for them and their heirs, and what does that mean in a long haul?
Sure. So let's throw out an example. Let's say that I own a piece of property in Florida, which I live in, and I want to give the property to you, Kristin, upon my death. But I want to be able to live in the property for the rest of my life. And I expect that I'm going to pay the taxes, and I expect that I'm going to keep the property up, and I'm going to keep it in good shape, and I'm going to do the things that I've always done with the property, but I just want the property to go to you upon my death and not have to go through probate. So I may deed the property, in that instance, if that is my goal, I may deed the property over to you, but reserve a life estate in myself. So as long as I choose to live at the property, pay the taxes, keep it up, I can do that till the day I die. But then you would, upon my death, you step in as the owner of the property, and all you really have to do to show that I'm deceased and to show that my life estate has gone away is to record an original copy of my death certificate with the clerk of the court in the county where the property is located. So that's a life estate.
And they have other names for that. I know the Ladybird deed, my favorite. And what else are they known as?
Well, sure. Sometimes people will want to go one step further than just a life estate. And let's say that I wanted to convey property over to you and keep a life estate in it. But let's say that I want to keep control over the property. I want to be able to sell the property if I decide to sell it without your consent or without you signing anything. I want to be able to mortgage the property. I want to be able to give it away. I want to be able to do just about anything with the property that I can do now that I'm the owner after I do this transaction with you. So I may do what's called a ladybird deed, or sometimes it's called an enhanced life estate deed, and sometimes it's called what we jokingly kind of call a poor man's trust. So what in a ladybird deed, what I would do is I would convey the property to you, but I would reserve in myself what's called an enhanced life estate, which gives me more than just the ability to live at the property for the rest of my life. It gives me control over that property for the rest of my life. And so lots of times when people are concerned about, passing away at some point in the future and having the expense of probate and whether their loved ones are going to get their property in a timely fashion, they'll speak to attorneys about different options, and a ladybird deed, and for some people, it's a really good option.
And this would also be a good option, I think, for a couple that maybe has chosen not to get married. This would be an option as well.
Sure. So what you're saying, if a couple has chosen not to be married, and they, and then they're getting up in years, and they want to make sure that probably in that instance, a good solution would be just for that couple to own the property as joint tenants with full rights of survivorship, because that way you've got it locked into place where if something happens to either one of the parties, the survivor gets the property free, in total.
Right. When we're talking about life estates and we're talking about an enhanced life estate, obviously you get a little more control over your property with an enhanced life estate versus just a normal life estate. What do you see as common with the elderly people? Because I know that you're in Sun City Center with a lot of elderly people. What is something that you see more often, the enhanced life estate or just the life estate?
What I see mostly when I find myself using life estates, mostly it's when someone decides that they want to put a piece of property in trust, and they want to set up a trust that states in the trust what happens to the property after after the person who creates the trust passes away. Maybe it provides for, as long as the person setting up the trust is alive, they're going to live in the property and have control over it. But upon their death, they want it to be handled in some certain way. Maybe they want the property to be sold and the money to be split between different people or charities, or maybe they want something special to happen to the property, so they would form a trust. Lots of times when I do that and people put property in a trust, I have them reserve a life estate. And part of the reason for doing that is, even though they're in complete control of their trust, usually the way the trusts are set up, they still reserve a life estate because we want to preserve the homestead property tax break when it comes to property. So lots of times by reserving that life estate, the tax collector's office sees, well, the person setting up the trust put the property into the trust but reserved a life estate, so they're going to continue to get their exemption, their tax break as far as the property taxes go. So I do that. That's why I do a lot of life estates. But usually if it's a scenario where someone is just wants to provide for the property upon their death, that's when we see the ladybird deeds come into play. They say, look, I want complete control of my property as long as I'm alive, but when I go, I want it to go to this person or these people. And that's a great, lots of times a ladybird deed is a great solution to that.
Yeah, it sounds like it's an easier way than basically doing a trust, or, when you don't have too much to put into a trust, maybe just one property, this would be a good option for somebody.
Right.
Well, I appreciate you joining me today, Scott, and giving us all this information.
It is always a pleasure.
And the next one I think we should do is on contracts. So I'll give a little hint to our viewers on our next topic with Scott. So I appreciate you joining me today, and you have a great rest of the day, Scott.
Have a great day, Kristin. Thank you.